who does your expired wills? I said, I don't think anybody does.
Yeah. I'm still, I mean, it's not time you do it.
One more minute. Well, good afternoon, ladies and gentlemen, and a warm welcome from a cool and windy Cape Town. I have with me Professor Steve Jeffrey, co-host this afternoon, and we have as our speaker somebody that needs no introduction because he's been here many a time before, Mr. Clayton Hall, who's head of legal at NatMed. Now, NatMed specializes in medical malpractice insurance coverage for healthcare professionals in private practice and in the state sector. And Clayton is this afternoon talking us through the topic, data privacy and the POPI Act, the rights and obligations of patients and healthcare professions. It's wonderful to have Clayton with us this afternoon, Steve.
Yeah, no, thanks so much, Clayton. Clayton's obviously the go-to guy, you know, with NatMed, and you know, very involved with a lot of doctors, and you know, and obviously interacting on a day-to-day basis with us, as well as we, you know, negotiate all these tricky legal issues. So it's wonderful to have Clayton with us, and yeah, I mean, what an important subject, and I'm sure we're going to learn a few things we're doing wrong at the moment with
it certainly is. In fact, those people that wish to have questions are very welcome. When the topic comes up, Clayton will take them timeously and at the time. I've already had a couple of questions, and most go along the sort of avenue of, do men and women doctors in the public sector need liability insurance at all? Or is it just for private practitioners? And another one's come in that I'm sure Clayton's going to be addressing. In terms of the POPI Act, can we share details with medical aids? We've addressed the questions, can we tell patients' mothers, which is sort of an old problem or not? And can we share their details with medical aids? So Clayton, without any further waste of time, I'd like to thank Wendy Brits, who's standing in for Karain, who's just had a baby. And we wished Karain last week, Steve, well with the baby. So are you able to hear us, Clayton?
Yes, I can hear you very well. I'm here and ready.
So we'd love to hear your talk this afternoon. Data privacy and the POPI Act, the rights and obligations of patients and healthcare practitioners. If you could share your slides, please.
Here it comes.
Questions as they occurred to them?
Yes, and I have jotted down the other two questions that you raised, so be sure to tackle those as well. Just a little bit about NatMed. So we're insurance brokers. We specialize in medical malpractice insurance, which we have done for over 20 years, offering insurance cover to private practitioners and healthcare facilities. And what that means is also that we see all of the mistakes. So wherever something goes wrong, the claim or notifications come to us, and we get a steady stream of what people are doing wrong and where the mistakes are being made, or where people are perceiving mistakes and making claims, even though there is nothing at all that's been done incorrectly. I'd like to just start quickly with a couple of polls. And these are the two questions, but the polls will pop up to get your answers. really what I'm looking for here is to illustrate kind of the fact that the POPI Act in one way or another touches most of our lives in daily practice, if not all. So please go ahead and select all of the ones that that apply here. The question is, have you ever received a request for copies of a patient's records from any of these following, either by a patient, or from a patient's family member, from an attorney on behalf of a patient, from the HPCSA, a medical aid? And once you've got critical mass, if you wouldn't mind showing us the answers. Okay, so 61% have received at least a request from patients themselves, 36% from a family member, 33% from an attorney. Luckily, not too many being asked by the HPCSA, certainly from an indemnity insurer. So, you know, only a few that have not received any requests for patient records. I think, you know, you're very much in the minority there with 21%. So, and each of these parties who asks for records, there's a different angle to it and a different consideration that you have to have when you're deciding whether or not you're entitled to share that information, whether you're entitled to share the specific records, what records you have to share, and indeed whether or not there's any limitation on the information contained in those records that you should share. If we could please have poll number 2 up. Have you ever shared a patient's personal or medical information with anyone, whether that's with a colleague for a second opinion or anyone at all, while not being 100% certain that you're actually legally or ethically permitted to share that information? You've got a few options there, and this is anonymous, so please go ahead and tell the truth. No one will know if it was you who frequently does this. All right. So we've got a pretty good spread here. Only 27% have never done this. And, you know, even in the once or twice, the occasionally in the frequentlies, it's really about not being certain that you might be permitted to do so. You might be doing everything right. But I think sometimes these rules they become so complicated or so, there's so many different sources for different rules around confidentiality, what you can share, how you share it. And I think that can just get lost sometimes in the noise, and you end up practicing the way that you have to, in a way that is rational and reasonable, and hoping that you're not breaching any specific rules or laws by sharing certain types of information. So I guess today we'll help to bring a little bit more of the certainty to where you can and can't share and what you can share, so that we'll bring a bunch of those down. Hopefully not reduce the amount of sharing, but just the certainty that you're actually entitled to and may use. So what is POPI, also called POPIA, which is one of those unfortunate things where we put the A in and then call it the POPIA Act when the A is for Act, but we'll ignore that for now. It's the Protection of Personal Information Act, and its purpose really is to protect the processing of personal information by public and private bodies, which balances the right to privacy against the reasonable right to access of information. Right? And it's seen as paramount in an era that supports free access to information, but also personal exposure on all over the place, right? Social media and all digital platforms. In terms of processing, what that actually means is, or at least how it's defined, is as an operation or activity or any set of operations, whether it's automatic or not, so it doesn't have to have a person actually specifically processing it, may be done by a system, and that concerns personal information. The activities include collecting, receiving, recording, organizing, collating, storing, updating or modifying, retrieving, altering, or consulting that information or using it in some way, disseminating it by transmission or distribution, or making it available in any other form. This includes publishing, it includes putting it out on Facebook or your LinkedIn, or even just WhatsApping it to a colleague. Merging, linking, restricting, degrading, erasure, and destruction. So these are all really around putting things together and making connections. So I think a little bit less common than A and B, but they did want to be complete. What is personal information? So we'll go a little bit more into the categories in here, but at the higher level, it's information that relates to an identifiable, living, natural person, but it could also relate to an identifiable and existing juristic person, which would be a legal entity. It's both public and private bodies, right? So by them, which naturally includes healthcare practitioners as well as facilities and institutions. And where it says it balances the right to privacy, of course, we've got that in the Constitution, the Bill of Rights, but it's also manifested in legislation, regulation, and codes of conduct. So it's in the National Health Act and in various guises as translated into the rules that apply to it in the HPCSA ethical guidelines, at least in books 4, 5, 9, and 16, but it's usually got a little bit peppered in book 1 and a couple of the others as well. And then the
Clayton,
yeah.
Clayton, could you just? I've always wondered what a identifiable existing juristic person is. Is that a judge?
No, the juristic person is a legal entity. So that would be an incorporation, a PTY limited, a public company. So like an insurance company is just a limited entity. It's no PTY. Anything that is effectively a corporate structure that has its own identifiable registration number and name.
So it's not a person at all.
It's not an individual person. It's a legal person. That's the juristic there is really just meant as legal. So it's an entity that they're giving these rights to as well. But great question, thank you, because it is quite confusing to anyone who isn't a lawyer and to some lawyers. And then balanced against the reasonable right to access that information, right? And now we can think of a few simple scenarios, right? Members of a care team who need to access information that has been processed, whether that's just the collection or receipt or whatever of information from one of the other members of that care team. This can be, you get information from the patient during the informed consent process. You might need to access a patient's medical records to defend yourself against allegations they've made against you or a claim that they've made against you. Or patients or their lawyers or other agent, right? In this case, that could be a patient's mother or a family member who's been authorized, also seeking copies of records. And there are ways and means of accessing that information. Usually we require somebody to do a PIA application, which is the Promotion of Access to Information Act. So on the one hand, you've got the protection of the personal information, and then you've got the promotion of access to that information, and they work hand in hand to make sure that those accessing that information is done.
Clayton, another question. It says the reasonable right to access of information between members of a care team. So it's quite acceptable, is it, or is it not, to have the nurses, the doctors, and the specialists on, for example, a WhatsApp group looking after a patient in ICU, so we all have access to each other's updates, examinations, findings, etc. Is that acceptable or not?
So what I've
been told WhatsApp is not. We've been told WhatsApp in a previous presentation is not secure. You might as well put it up on a billboard.
Well, it's not secure from the perspective that there are multiple parties on that WhatsApp group, and any one party could leak that information or use it improperly. And so the correct safeguards aren't in place. in terms of the actual information in WhatsApp, it is all, it's all encoded. It's not that WhatsApp can access it or that it could be hacked, for instance. It's more around the it's the lack of control over sensitive information that makes that less appropriate. But you can still do it, and you can still do it specifically if you are limiting the members of the group to the specific members who would need that information. So it's not just everybody who's involved, and that you limit what information is shared to only that information that needs to be shared amongst the members of that team in order for them to act appropriately for the beneficial therapeutic benefit of the patient. Yeah.
So it's quite permissible. Is that what you're saying? The bottom line, you may do one WhatsApp group.
Yes, you can do a WhatsApp group. It's what's going to be reasonable in the circumstances. If there's not a better method to have rapid dissemination of information between members of a care team, then that should be permissible. It's I think on a case-by-case basis. If it's for every single patient and there's not, it's not in an ICU situation where there is a multidisciplinary care team, for instance, it may not be considered permissible if it is kind of members of is not strictly speaking members of a care team or currently involved in the care, but maybe there was a referral, for instance, and you're keeping the previous practitioner aware of the condition of the patient. That may not be seen as viable because they don't, strictly speaking, need that information. They're not currently treating the patient. It has no impact on the patient's health. So, you would need to just assess for what purposes is the group form. But bear in mind that I put these bullets in here. These are not contained in the Act. It doesn't include specific mention of members. But a few examples of kind of the illegal information processing. Right? So one would be taking a photograph of a patient's wound or any body part without getting their explicit consent. Taking a photograph of a patient's hospital label, for instance, and storing it on your mobile device without actually doing anything to safeguard the access to that information. So if it's just sitting there in your photos, that gets uploaded to the cloud. It sits in Apple Photos or Google Photos, and there's a database that is outside of the country or somewhere in the cloud where that information is stored, and it is not secure just because it is guarded by your own Apple ID. It's as we know from multiple stories of leaks of people's personal information from their phones, that is not secure. Storing patient information on really any data storage device in the cloud or in any kind of database that doesn't have restricted access. So if you have, for instance, a PC at your front, at your reception, and that actually has access to patient information on it, but there's no password, that is considered illegal information processing. Accessing any patient information on a public computer and leaving it open. So, just hop into your, insert your favorite pathologists here into their platform to go and check on some records and leaving that open. Of course, that would also be a legal breach. And then storing patient information without having any real anticipation of legal, research, or administrative value for longer than the period that you're required to keep it for. Now, this is an interesting one because typically we would say, and if you look in the HPCSA booklets, it actually says that, if you can reduce the medical records to digital format, then they suggest indefinite storage of those records, rather than specifically the physical records where there are cases which are 5 years, 6 years, or up to 21 years, depending on the specifics of the patient and whether or not, what the reason is for keeping those records. So I find this to be a quite an interesting one that I don't see there being any real way to execute on this one, given that you never know when a claim might be brought. So you can always argue that there's the potential for a legal claim, and that you would need those records to defend it.
So, Clayton, can I just ask you then, so an Apple ID isn't considered to be enough protection. I mean, I thought that Apple was actually quite secure, or was that not? I mean, Apple hasn't been known to leak or divulge information. Is that not legally considered to be good enough sort of a firewall?
Yeah, it's not. It has to be stored within an app that restricts access further. So behind something that is password protected in a vault style app, something that is more than just the on the phone storage. So it can't be just stored in the photos. It has to be saved behind a further layer of protection.
Yeah. But if it is an international type app or something that has got a good password protection, it still seems to be okay. Or does it have to be a local sort of storage system?
Typically, those storage systems have been designed to be secure, specifically to limit and restrict access to only the people who have the right passwords and have uploaded that information, and then it's actually stored in ways that keeps it secure as well. So as long as there's some comfort that app provider has at least said that they have these restrictions in place. I mean, you're not required to go and check on the coding and make sure that everything is secure. But if they have purported that it is secure and that they're complying with these guidelines, then it's safe to do so.
Okay, thank you.
Sure. So then let's talk a little bit more about what actually personal information is. And there is a lot that qualifies as personal information. So we talked about it at a high level being relating to identifiable living natural persons and where applicable, identifiable and existing juristic persons. But the type of information that qualifies as personal information is information that relates to race, gender, sex, pregnancy, marital status, national, ethnic or social origin, color, sexual orientation, age, physical and mental health, well-being, disability, religion, conscious belief, culture, language, and birth, information about your education or medical, financial, criminal, or employment history, any identifying number, symbol, email address. So all your details around phone numbers, your email address, your ID number, your home address, all count. Biometric information of the person. This is height, weight, eye color, even images of a person, because that image of that person contains biometric information, because you see a photograph of somebody and you can tell generally how tall they are. If there's something in the photograph that provides you that context, you can see their eye color, you can see what race they are. There's a ton of information that is contained in images of people as well. Information around the personal opinions, views, and preferences, correspondence sent by people if it's implied or explicitly noted that it's private or confidential, the views or opinions of one person about another person, and the name of a person if it appears with other personal information, such that somebody who knows the name can then link the personal information to that person. So a minefield, and you can clearly see from this that healthcare records, your patient files, contain a tremendous amount of personal information, right? The health records, I'd say apart from people's opinions and views and preferences, it contains all of the address details, everything that identifies a person specifically, because you also want to be able to identify that patient and to be able to seek, payment from them or get their medical aid information. And you have to know a whole host of information about them, their well-being, their health, their age, etc., in order to treat them appropriately. So the health records are just replete with personal information, and so it's really just consider all health records as being POPI applying to all of your health records. And I think it's safe to say that unless something has been specifically de-identified and you've gone through it and taken out any identifiable information, for the most part, it is just safer to assume that any record that is produced has personal information. So something to think about. Now, these people didn't have green round faces. That was me, because I don't want to, in illustrating the rules of POPI, to breach POPI. So imagine you can see their faces. This is just somebody posting. It's a young doctor, a young nurse, an innocent post celebrating the cuteness of an adorable baby. But in reality, it's sharing personal information without permission or consent. Right? There's personal information here. There's race. There's at least a guesstimate of age. There's an image or photograph, which means that biometric information is being provided. So, in something that's meant to be a cute little Instagram post, it is actually a breach of POPI.
Clayton,
Yes.
go back to that cute, adorable baby, the one on the right. It's almost axiomatic that baby cannot give permission. At what age can you give permission? So can you ever show any picture of any cute, adorable children even, because they are unable to, or are they able to give permission legally?
It would have to be with the parents' consent. So the parent can give consent for the image of the baby.
I see.
Yeah.
Okay, so if the parent says you can take a picture, that's also kosher.
Yes.
Okay.
They say you can take a picture and you can publish it. So taking it and publishing it are two different things. So you have to have the permission also for the way in which you intend to use the image. So
if you just want to take a picture for many doctors, me excluded, take pictures of the babies they deliver and put it on a wall for reasons I can't imagine. So technically, you can only do that if you ask the parents, can I take a picture of your baby and put it on my wall?
Yes, that's correct.
Okay.
That's right. Because it has to be for the specific intended use, and the consent has to relate to the intended use.
Okay, thank you.
A quick and innocent Instagram post for somebody who's excited about their new office, but there's patient information visible in the background, and there's a patient file open and also contained in the photo. So also breaches of POPI contained in this image.
But Clayton, where do you draw the line? If you could, that picture over there's also pictures of naked people over there in skeletons. Does this not become slightly ridiculous? As if you are analyzing something like that, where do you actually draw the line? Because who is going to follow up and say, hey, that's my X-ray there, and who said you could put my picture up and my X-ray up? Is this an actual factual problem? Does this become an issue, or is it just a theoretical thing?
It has been an issue, but it's we use it as a theoretical thing, but it has occurred. It's not just in the air. Certainly that has happened. We have cases of practitioners who have posted pictures of patients' genitals on social media platforms. Patients who have been undergoing surgery and have had photographs and stuff taken of them and posted on public forums. So yeah, it's actually those are the images there are more innocent, but the real stories are actually a little bit more severe. It certainly does happen.
So it means that if you're ever going to take any clinical pictures, you always have to have information of the actual owner of those clinical pictures. Otherwise, you are opening yourself for liability then.
Absolutely.
Okay.
You must have. And you can take that consent up front, right? So it doesn't necessarily have to apply to every instance. So, can I take a photo of your ankle? Can I take a photo of your knee? Can I take a photo of, your face, whatever it is? If there are injuries there and you have, for instance, let's say you've got your practice letter, and in your practice letter, you have in there the consents related to POPI. You can state in there the ways in which you utilize and process their information and get an upfront consent to taking such images and the purposes for which you want to use them. That also needs to include a note that the patient can withdraw their consent at any time. So once given, it's not a perpetual consent. If, for instance, they've signed the practice letter, and in the practice letter it says you give me consent to take, clinical images, including, the images taken through the laparoscope, the videos that could be taken with those cameras, etc. So you include those categories of information, but they can at a later stage say, you know, I don't want you to use those images, or I don't want you to use that information, and withdraw that consent. But what you mentioned about
sorry, Kate, we just got a question here. It's just come up. Some people record interviews in their office in the normal practice of a clinical interview in history taking. Would that be breaching the POPI Act if the patient has not given any permission for this to happen?
Yes.
Okay.
Yes, it would. Because if you look at the definition, right? So if we go back to the definition, it included in processing is collection, recording, right? Storage. So that information that is being given during the audio recording is you're collecting information from the patient. They are giving information that is personal information, because it will likely relate to their health status or to other aspects of them. You are recording it. You will need to store it at some point. You know, if you consult it or use it, it all fits into the definition of processing. The information that will be in that, likely, you know, they will have said their name, or they'll have said some information that makes it identifiable, and then they will have mentioned many of the categories of information in here that's personal information. And so, without them giving consent, you are specifically processing personal information without that individual's consent. So it would be
okay. Thank you.
Yeah. But the word identifiable there gives you the clue to the other question that you asked, which is in an image like this, right? What's identifiable is that X-ray typically will have a patient's name written on it, right? So it's the patient's name together with other information that links that information to the patient. And that is under this category here of the name of the person if it appears with other personal information relating to that person, right? So it's under category H. And the other information, or other personal information that is included in that, is information about their physical health, their well-being, and it includes their name, so it's identifiable. So in those cases, with an open file and with an X-ray on the back, those are things that will be identifiable, and that's why it creates a breach. Anything that's used for research that's been de-identified, that is a nameless picture of a pelvis, or picture of some musculature or whatever, can't possibly fit under the definition because it's not identifiable. There's nothing that links that to an individual that somebody could say, oh yeah, that's the skinned body of Joe Bloggs. I remember, what his muscles look like. It's not going to, if there's a cadaver and the cadaver is labeled and it's got a person's name, then that is personally identifiable information, but it's the person is not alive. Because it's
so Clayton, another question. If you if you're doing a talk and you get some images off the internet, are those subject to the POPI Act or not? Because they're obviously in the public domain.
Yes, so they're in the public domain already, which means you have not. So yes, it's one of the categories that say it's not an unlawful breach of POPI. It's lawful use of information if it is already in the public domain. So if you've taken, let's say you take a picture at a conference, right? And you're all in front of a particular stand, and there's a person in it who hasn't given you permission to publish that photo on your social media. Their face can be seen. And they say, well, I didn't want anyone to know that I was at that conference, and now they do know, and you've published a picture of me. It's clearly me. People know who I am and where I am. But they've published a similar photo on their own Facebook or on LinkedIn. They've got no case because they've already put that information in the public domain. And so it's the same thing. If that information is already out there, then you are not revealing the personal information. You're simply using something that's already public domain.
Okay.
Yeah. Okay. So a few kind of intentional and unintentional data breaches. Intentional would be really just directly sharing confidential patient information without their consent. Discussing a patient in your reception area in earshot of other patients. sending a WhatsApp to your receptionist's personal cell phone about a patient's healthcare, right? Because it's not secure, and it's not part of the agreed sharing, which would typically be included in a practice letter. Unintentional, you may, as you said, you may be posting a picture of your office, but there's patient information visible in the background. Another patient's file left open on your desk when a different patient comes in. These are all kind of unintentional breaches of POPI.
Clayton, one more question just come in now. If you're discussing a patient in a lift and you haven't mentioned her name or his name, is that a breach of the POPI Act? If you're saying I've got a patient who's got a very large ovarian tumor, for example, should you not do that in public? Or if you're just riding up a lift and want a quick consultation with your oncologist friend, may or may you not do that?
So it will depend on how identifiable the information that you are disclosing is. So for instance, if you say, I have a patient, they have X, and that's it, then that should be completely fine, right? It's always preferable to do it in private if you can, but if you need to, it's totally fine. But if you are saying something more like, oh yes, I have a patient that has this, and they go, oh, is that the one who also had the left below-knee amputation? Yes. Oh, the one from Benoni? Yes. You're adding more information in that makes it more likely that that person could be identified. Whether or not somebody is actually going to go and decide that they want to go and find this one-legged person from Benoni is beside the point. It's more that you just need to keep the information as restricted as possible. So in those situations, only discuss what is strictly necessary in order to kind of get to the answer that you're looking for to get to the result of that conversation, and don't share anything extraneous.
So Clayton, the increased use of iPads, phones, etc., obviously makes this quite tricky. And Amri's Basson's actually brought up an interesting question as to in Netcare, we're all using this Care-On system now, and she wants to know how POPI Act compliant is this Netcare Care-On policy. Currently, anyone with an iPad, doctor, nurse, has access to every patient's personal details and results. Now they do have some data walls, etc., but by the time you can actually you access it, then it's a free for all. Do you know anything about the Netcare system?
So I do know a little bit about it, but not enough to be very specifically critical of it. I'd say at a general level, the fact that everyone has access to every patient's personal details and results by itself would make it not POPI compliant. And that's because you should have restricted access to only those people who should have access. Now, they may have countered that with their patient agreements for when patients come into the Netcare hospital and they agree to be part of the Care-On system. And I haven't seen a Netcare admission agreement in some time, but I would imagine that the way that they've dealt with this is by including it very specifically in that admission agreement, and to say that all members of the hospital involved in their care will have access to this information, so that effectively the patient gives consent for a broader use of their information. Without that, my sense is that it is not POPI compliant unless they really get the proper restrictions in place to make sure that that the data flow is only such that the people who are involved in that patient's care can even see that patient on the system, because merely having their name and any other detail with them visible on the app would just by itself be a breach of POPI.
Thanks, Clayton. One quick one. We've got lots of questions here. Habib M. Habib, who wishes to remain anonymous, says, if a woman is HIV positive, are we obliged to share that with her partner, or are we obliged not to share it with her partner, that information?
Yeah. I actually do not know what the current rules are on that, to be honest with you. I know that it used to be the case that you would first have to counsel the patient to make the disclosure. And then if you had a reasonable suspicion that the partner was being exposed to risk of transmission. They had not disclosed it. That disclosure would be considered in the public interest. But I have not looked at the rules around that or any updates in the legislation or case law in some time. So don't hold me to that.
Oh, so you're not exactly sure? Because I had a case recently where the patient's husband says, "What's this ARVs that you're prescribing for my wife? I've noticed in the medical aid." And she hadn't disclosed that she's HIV positive. He may or may not be positive. That's beside the point. But it actually puts a person in a very difficult position and on the spot there and then. Okay,
Yeah,
thanks.
absolutely.
So you wouldn't know that either, that answer.
No, but I will very happily go and just research that to make sure I can get what the real answer is currently, and happy to provide that to you guys as a follow-up.
Things might have changed as well, Pete, because the risks are much lower now when patients are undetectable. The partner might not be at risk anymore. So things might have changed a little bit as well in terms of how we.
Yeah, but I had to think quickly. He said, "Why are you giving my wife ARVs?" So there she's standing behind him, gesticulating wildly. And I just said, "So she doesn't get HIV." So that seemed to mollify the guy. But I mean, for a half a second, I was really very unhappy.
Quite quickly after that.
Yeah. And I know it can be quite hard to think on your feet in those situations, but gesticulation aside, one way to do it is just to say, I can't tell you that. You'd need to speak to your wife.
Yeah.
Then Angela Hardwick also wants to ask, if your phone is not connected to the cloud, is it still incorrect to store patient information on it?
It's typically not okay unless you have a specific secure storage vehicle on your phone. So even though it's local and only stored on the phone's storage, it's unless you have put that behind some sort of secure like a vault or app or something like that that encrypts it or encodes it, it's usually not considered sufficient to have it just stored on your phone.
Okay, and then thanks. And then Angela also wants to know, why does a patient who requests a copy of their own file need to complete forms for a request?
They don't, actually. But what we typically do is make sure that the request is in writing. And if they have asked you to provide a copy of the file to anyone else, then they need to have given you an express consent to do so. So I think that it's become just common practice to get everybody to sign a form. But if a patient is asking about their own records and want a copy of their own records, and they've asked you directly, you're entitled to release a copy of those records to that person without any forms being signed.
Okay, and then your friend Bib is also asking a patient's family member calls to inquire about a patient's follow-up appointment date. Am I allowed to provide info regarding this? An example, an appointment at oncology when the patient hasn't disclosed his or her diagnosis to the family.
How much can you share with the family?
Yeah. So usually you can only really share with a family in situations where the patient is unable, right? And so you're needing to contact the family to get consent, or if they're in if there's palliative care and where the ethical guidelines specifically state that you should involve the family. But for sharing of information, you are not really at liberty to share information with the patient's family unless the patient has given you consent to do so. And so it's always the first port of call is to get consent from the patient and to make sure that they are comfortable with you sharing information, and then to make sure that you understand what information they're comfortable with you sharing before you share with family members. It is not a family member's right to have any information about their other family members' health status or appointments or anything at all.
And is the age of consent 18? So if you're under 18, they can, or if you're over 18, you can't.
It is actually a little more complicated. It's 12 with 12. Maturity. So if you are over the age of 12 and have sufficient maturity to understand the effects of giving consent, then you are entitled to consent to the release of your personal and medical information from the age 12 up, and to also refuse access to that information from the age of 12 up. But it does require an assessment of the maturity of that individual. And if you, as a practitioner, are of the view that the 14-year-old in front of you does not have sufficient maturity to truly understand the impact of giving or refusing consent, then it would be the parents who have to give consent.
Thank you. Well, you better carry on, Clayton. Otherwise, we've got so many questions. We'll tie you up all afternoon.
We'll come back to a few questions shortly.
Okay.
All right. So who are the main parties under POPI? There's the data subject. That's the person that the personal information belongs to, right? And in this case would be a user as defined in the National Health Act, or a patient, right? So that can be a natural person, like an individual, which would be your patients, or a juristic person, which are the legal entities like companies who we can't exactly treat. And there have to be measures in place to protect their personal information, right? And this is where the can it be on your phone, can it not be on your phone? It's reasonable measures to protect the personal information. And it's typically not considered reasonable, sufficient protection of that personal information to have it simply stored on your phone and not secured somewhere else. Then there's the responsible party, and that would be the public or private body that alone or in conjunction determines the purpose of and the means for processing that personal information. This would be most of you. So you would be considered the responsible party. And then there is also a party called the operator, who is the party who actually processes the personal information on behalf of a responsible party. That would typically include your staff. So your receptionist might take people's details when they're first doing their putting the details on the patient file, or invoicing patients, for instance. That also is processing personal information. But they do it on behalf of the responsible party, which is you, because the patient wouldn't be there unless they were there to see. And then there are the 8 conditions under which the processing of information is really considered lawful. So here are the 8 conditions. One is around accountability, and I'll scoot through these so we've got time for a few more questions. The responsible party is always accountable for the personal information that it processes or that's processed by operators on its behalf, and it stays that stays accountable for that personal information, even if you pass the information on to a third party, like the operator, to process the information on behalf. And that would mean, if you're using an external party to process accounts or anything like that, you're still responsible for the personal information that you provide to them for the processing, right? And that responsible party is the entity that has that needs that personal information for a particular purpose and determines how it must be processed in order to achieve that purpose. So you also, for instance, if you are taking a photograph of a patient's wound and you need to send it to another member of the care team, you are the responsible party who has processed the information in the first place, and you are also distributing it to another party, and you remain responsible for that personal information. So that if that person, that other person discloses the information and you didn't confirm with them that it's confidential information and shouldn't be disclosed, you can also be liable for the disclosure, because you are still responsible. There's a processing limitation, right? So it has to be processed lawfully and in a manner that doesn't infringe on the data subject's privacy. It doesn't infringe on the data subject's privacy in the understanding that their right to privacy is limited, and the limitations necessarily include all of the lawful processing of the information. So anything that is a lawful manner of processing it isn't trumped by their privacy. It is already considered lawful, and so that's a limitation on their right to privacy. When processing the personal information, the activities must be adequate, relevant, and not excessive, taking into account the purpose the information is being collected and processed for. So for instance, if you have a real penchant for data and you actually ask your patients for way more information than you actually need in order to treat them, to process their accounts, to do that sort of stuff because you actually just like data, it's not going to be considered a lawful use of or lawful processing of that data if it's being collected for a process that is more extensive than what's actually required for why you're genuinely collecting the data. And there's a general obligation to obtain consent from data subjects to process their personal information. And it also sets out the justifications in instances where consent will not be required, like when you have to defend yourself against a claim in court, or where it's in the public interest. It's the same kind of rules that apply to just releasing confidential information. Condition 3, purpose specification. So the personal information has to be collected for a specific and lawful purpose. So for instance, if you are collecting a blood sample and then you need to write the person's name on it, you need to collect certain other information. It's that you're collecting that for that specific purpose, and then the information that is gathered there will be used for the purpose of identifying that sample, for processing it, and then identifying or linking the results to the sample, which is then linked to the person. So all of those aspects of it are part of the original purpose specification, right? And the responsible party has to identify what the purposes are for processing that information and ensure that the data subject is aware of that. So if you are collecting information, you also need to make sure the data subject is aware that you're collecting and processing that information and what you're collecting and processing it for. For instance, cord blood gases. I'm sure you've seen the consent forms that specifically state, we'll take a sample of blood from the cord. This is for the purpose of establishing certain metrics at the time of birth, and what will happen to that information, where will it go, and how will it be used. And it's quite encapsulated in quite a neat section. But because you've done that, any use of that information outside of what's been written into that consent and agreed to would be unlawful. The purpose spec condition also regulates document retention and document restriction. It generally requires that the personal information shouldn't be retained for any longer than is necessary to achieve the purpose that it was collected for. And that's subject to any documentation retention periods prescribed by law, but that includes then the HPCSA guidelines for how long you should be keeping records. And that's all in booklet 9. And so as long as you're complying with the time periods in booklet 9, there should be no issue with the retention of the records or retention of that information. There are only a few more, right? There's only 8, so we're almost there. Condition 4 is further processing limitation. It says that that information must only be processed for the purpose it is being collected for and no other purpose. And really that also means that once you have processed it, you can't then use it for any other purpose, or as long as it's still personal information, you can depersonalize it and use it as part of a larger data set to do analysis or to do research on. But it's typically best to also get consent from the data subject that, or at least inform them that de-identified data may be used in that fashion. But using it while it is still personal information there's a limitation on that for the processing. So doing that without a specific additional consent would not be. Condition 5 is information quality. You have to take reasonable practical steps to ensure that the personal information records are complete, accurate, not misleading, and updated where necessary. There are also conditions specifically around this kind of information that are contained in booklets 5 and 9, if I'm not mistaken, of the ethical guidelines, where it specifically states what a complete health record looks like and what are the elements of a health record that should be there to make it complete. I think there are also requirements on accuracy. Condition 6, openness. So you need to be open about why you need the data subject's personal information, how you intend to use it and process it. I know it says businesses, but really your practice is considered a business. And the data subjects must be made aware of who's collecting that information, what's being done with it. There's certain prescribed information that they have to be told about when it's being gathered, the purpose for the collecting of the information. And we just suggest have a POPI section in your practice letter that just gives all of this kind of consent upfront by the patient, acknowledges that they can withdraw it at any time, and make sure that you then have the freedom to process that information and use it as and when you need it in order to actually deliver the healthcare to the patient, which is what they're there for. There's the security safeguards. So the responsible party has to take appropriate, reasonable, technical, and organizational measures to secure the integrity and confidentiality of the personal information it processes and to prevent loss, damage, unauthorized destruction, unlawful access to or processing of the personal information. So this is where the phone question comes in. You know, if you are able to use a simple code or some really not that secure method of getting into your phone, then it's not considered sufficient storage, especially when things do go into the cloud and there's a potential ingress from bad actors who can access the cloud. So really having these things in a storage mechanism that is encoded, encrypted, or that has specific security protocols is the best course of action. And when it's on your own computers in your rooms, just making sure that you have everything is password protected, that you have backups, and that you also have the right firewalls and a good antivirus or anti-incursion software on your on that device. Physical and technical security safeguards, because not all the records are digital, right? Some are actually just physical files. So this is just also making sure that your the premises where hard copy records are stored are also properly secured. And then people, there's access control. People don't just have the ability to wander into an office where those records are stored, that those doors are locked, that the file cabinets are locked, that there's some attempt to properly safeguard access to those records. And last but not least, the data subject participation. So the data subject also has a right to ask whether the responsible party holds any personal information about them and to request the details of what personal information is held and a copy of that personal information and the details of anyone who has had access to that information. The data subject also has a right to request their personal information record to be corrected, deleted if it's inaccurate, irrelevant, excessive, out of date, incomplete, misleading, or obtained unlawfully, or the personal information record be destroyed or deleted if the reasonable party is no longer authorized to retain it. So you may have had the right to retain it, and then your right is gone, either because there is nothing that has a prescribed period for which you need to keep that record, or because the purpose for which you were keeping the record has ceased, and so you no longer have a legitimate lawful reason to keep or process that information. Okay, so we did. I think we've already had a couple of questions. We've got a few minutes left, and I see there are a couple of questions up. So happy to take a few more.
Thanks, Clayton. It's very comprehensive. Angela has basically asked us 5 questions. So I'll start at the beginning. Is there a way to secure Google Sheet so that storing patient information on it can be POPI compliant? And I suppose it comes down to the same to all these generic platforms. I use a system called GoodNotes. I mean, what are the basics of this that we should be looking at if we are using something more like sort of off the shelf?
Yeah, truth be told, that's a kind of a technical question. And so, I mean, I certainly don't know on the Google Sheets side, but it'd be what is reasonable and sufficient, in that case. So is it secured? Does anybody else have access to it? How do you access it? Is it with a personal password? Is there 2-factor authentication on it? And what are the security protocols that are used by that app in order to secure the data? And where are they keeping it? So is it in the cloud? Is it on a recognized cloud service? All of that information would come together to determine whether or not the technical safeguards are appropriate. Typically if there is an app or there's something that's been created specifically for safeguarding medical records, usually they will advertise all of their security protocols, suggest that it is compliant. But I'm sure there must be ways of securing Google Sheets so that it is POPI compliant. I just don't know what they are.
What actions should you take once you realize you have accidentally given a patient information to someone who did not have the right to it?
Two things. One, you should ask that person to delete the data without looking at it and to confirm to you that they have deleted that. And then secondly, you should alert the patient or the person whose information has been leaked that there has been a leak of their information and what steps you've taken to ameliorate it.
Okay. And then are patient files POPI compliant if they contain all the details on the front cover?
They are if that file is not exposed to members of the public or other people who don't have a right to access that information. So if you have it all on the front cover of a file, then you should never put that file down at reception, for instance, because then all the information is sitting up where people could see it. If you have that information obviously inside and you've got a folder on top, then it's okay. But if it's strictly kept back office, it's okay to have that information on the top of the file. If not, then it's not.
Okay. And then I think this is actually quite an important one. If I'm accessing patient information on a database open to clinicians, should I request consent from the patient to access the information? So a good example, and I've actually been wondering about this. I mean, we can all access through Morton. We can access X-rays for their whole database, just with a simple password. The same is for PathCare. Yeah, so I mean, they don't seem to be too worried about everybody with just a normal simple password being able to access the whole database. What do you think about that? And where's the line drawn on those things?
So on that, I think it is quite dangerous to have all of that information available like that. We had a case recently where a practitioner accessed a patient's records, their pathology results, and gave it to a third party. Neither that practitioner nor the third party are involved in that patient's care in any way, but there were personal things going on with one of their husbands and that patient, and they wanted to understand some information about what was in that result. And the only reason they were able to access it was because the security was quite lax, and you actually do have access to patients' records and results when they're not your patients. So I think that is definitely a breach. In terms of the specific question, which is, should you ask the patient? It depends, and here's what it depends on in my view. It depends on whether or not there's a reasonable expectation or an already given consent by the patient that the information that was processed by the practitioner or pathologist who prepared those results, gathered the original sample, whatever it is, that they would be sharing that information with other members of the care team, which includes you. Now, whether or not that includes you specifically, so there may be a consent that says, will anyone else in the members of the care team or whatever who may need to have this information, if you fall under that, then you don't need to specifically ask the patient for consent. But let's say you have a new patient and they've said, oh yes, I have, or you look and you see that your patient has a bunch of old results, whatever, on the platform that you're using, and you're interested in that history, you certainly should ask them before you access that information, because they haven't given you consent to do so, and there's no legitimate expectation that you would be accessing that information, and it doesn't fall under anybody else's consent.
Yeah, I mean, this is quite a complicated thing, and I think our colleagues running these platforms certainly need to tighten up on their security, because I think there's a lot of potential for data breaches with some of the stuff that we currently access.
Yeah, and we've seen how easy it is, and we've seen it being done.
Yeah. Just 3 more quick questions. It is time to close, but quickly, if you consult with another doctor via WhatsApp, should you put your picture on auto delete? maybe not a bad idea.
Yeah, I mean, I think it's a mechanism to limit the use of that personal information purely for the purpose for which it's intended, and to limit the storage to the purpose for which it's intended and the time period. So yeah, I think that is that is certainly something that would be helpful.
Okay, and then just two very quick questions. Is there, if there's a radiological referral, is one obliged to send the patient the report? Patients are often asking for the reports, and I think sometimes they get the reports before we get them.
Yeah.
Yeah, I don't think it's an obligation.
My results yet, and I think, are they available? Sorry?
Yeah, I don't think it's an obligation to send the results, but certainly there's a right for them to have them if they want them. So if they ask for the results, then you should certainly send them.
Oh, they normally get them from the lab themselves, or the radiologists themselves. This is I think this must be someone who is scared. Can a nurse use the cell phone light to help the MO visualize the cervix while performing a speculum examination?
Do you understand that question, Clayton?
I do. I mean, I wouldn't advise it. But if you absolutely have to, I guess that's deeply personal information that would be maybe the patient should consent to that.
If you're only using the torch, fine.
But you can do a video. I mean, they don't know that there's a video that you're doing if there's a light on.
Yeah, it should definitely not be a video, and probably just holding the light this way and not looking.
Yeah, sometimes you have to do what you need to do to make things happen. Eh? So
Yeah.
be careful. All right, well, thanks so much. That was very informative, and I'm sure you've taken us a long way in terms of making sure that we're protected and our patients are protected as well.
Just before we sign off, Clayton, a big thank you. I'd like to echo and descant Steve's feelings. I'm just going to ask if, as I said at the beginning, Karain, I've got her details, but I don't have Wendy's details. If Wendy could just WhatsApp them through to me so I could send the questions through to her. I seem to have lost her WhatsApp details. So
not a problem, Doc. I'll WhatsApp you now.
Thanks, Wendy.
No problem.
Thank you, Wendy, for all your technical assistance. Thank you, everybody. And we look forward to seeing you again next time.
And thanks
Absolutely.
again, Clayton, for taking time to give us such a comprehensive overview. And we look forward to seeing everyone next. Is there still one next week? At school holidays? There
are holidays coming up, and we do, as you know, knock off Steve, because I know I'm going away, you're going away, and Clayton's going away. So we're going to just to confirm that and see when we do knock off holidays, because we have talked about this, and we know that there is a break for people can have a bit of a breather and go on school holidays. Many of us, including Steve, have got small children. And for that reason, we do go away during school holidays. And I'd like to thank you once again, Clayton. All the very best, and thanks for the time, and for those delegates who've logged on as well.
Very welcome. Look forward to the next time we get to chat.
Okay, thanks, Clayton.
Bye.